Hello viewers, today we will discuss on law on social evils faced by women in India. The objectives of this lesson are firstly to list the major social evils that affect a woman's life in India. Secondly, to examine the laws dealing with the child marriage, Sati, widow remarriage, immoral traffic and indecent representation of women. And lastly, to suggest measures to ameliorate the socio-legal position of women in India. Violence against women is a violation of basic human rights and a form of discrimination against women. Gender-based violence results in physical, sexual, psychological, economic harm or suffering to women. The male-centric society perpetuates various kinds of societal evils to control women and uses them as reasons to justify the curbs placed on women. In this lesson, we shall focus on a few of such social evils that reflects the socio-legal position of women in India. Let's now examine a few of these in detail. We will firstly discuss the law on child marriages. Child marriage in India refers to any marriage where either the woman is below age 18 or the man is below age 21. While child marriage can happen to members of both sexes, it unduly affects girls. As a common practice in India, the daughter is married off at a young age to relieve the family from her economic responsibilities. Many factors perpetuate child marriages even in the 21st century, such as ignorance, poor literacy levels, social customs, traditions, etc. The 2011 census of India revealed that 12 million persons were married off before they reached 10 years of age. A staggering 65% of the 12 million were girls. It is shocking to see such soaring numbers even after 80 years of India's legislative efforts to curb child marriages. Child marriage is a special evil that endangers the life and health of a female child who is not physically ready to withstand the stress and strains of married life. Keeping this in mind, child marriage was outlawed with the passing of the Child Marriage Restraint Act 1929 during the colonial times itself, which was the first secular law towards curbing the menace of child marriage. The act aimed to prevent the solemnization of child marriages, but did not make the marriage void by itself. It only prescribed lesser punishments for an adult male who married a minor and the parents who promoted such marriages. However, it largely remained a dead letter and failed to achieve its objective. India responded to the limitations of the Act of 1929 after 76 years of replacing it with the prohibition of Child Marriage Act 2006 with prevention, protection and prosecution as its three primary pillars. The 2006 Act makes child marriages voidable by allowing the children in the marriage to seek annulment. Such marriage shall be void ab initio if the injunction prohibiting a child marriage from taking place is violated and shall be null and void if the child is taken away from their lawful guardian by enticement, force or deceitful manner or is sold or trafficked for the purpose of marriage. On such annulment, it provides for the maintenance and residence to female contracting party to child marriage until her remarriage. It provides legal status to children born from child marriages. Enhanced punishments to the offenders and appointment of child marriage prohibition officers speaks of the progressive efforts of law in eradicating the evil. The Act appears to be self-sufficient with a few inconsistencies with other laws. While the Act of 2006 punishes the parties and other persons involved in the solemnization of marriage, the Hindu Marriage Act 1955 punishes only the parties to the marriage. While the Christian law permits minors to marry, the Muslim and Jewish law permits a girl to marry on attaining puberty. In contrast, a Parsi child marriage is invalid. Thus, we see most of the personal laws of the country do not invalidate a child marriage on its solemnization. As a consequence, minor children have no choice but to enter a sexual union once married, and sex with a child, willing or unwilling, becomes legal. This lack of uniformity is addressed by the Delhi High Court, which held that the Act of 2006 prevails over the personal laws in Lajja versus State. The judgment in this case also proves a stepping stone for removal of two major injustices faced by the women: child marriage and marital rape. The confused approach of Indian law on prohibited child marriage relationship is evident in other secular laws as well. While Section 375 of IPC allows marital rape of a girl child between 15 to 18 years by her husband, Protection of Children from Sexual Offences Act 2012 treats such act as an aggravated offence. It is time for the judiciary to declare marital rape within prohibited child marriages as unconstitutional. While the Immoral Trafficking and Prevention Act 1986 declares all forms of sexual exploitations as crime, the otherwise legal validity of marriage conferred by the secular laws protects the perpetrators coercing a child within a marriage. Even though India has drafted many critical laws for children, the laws do not always complement each other and at times contradict each other. Such contradictions need to be corrected, and a uniform stance needs to be taken across all laws pertaining to children, integrating them under one umbrella. Sati. In traditional pre-independence India, married women were identified with her husband and had no individual identity or rights. On the death of her husband, they were generally shunned as ill omens who deserve an isolated life because they have brought death to their husbands. They were either coerced to live a life devoid of any happiness, comfort and companionship, or are forced to die in ritual sati. Sati is a practice where the widow burns herself in the funeral pyre of her husband. Bengal region recorded high incidences of sati due to the existence of Daya Bhaga system, which gave property rights to the childless widow, and therefore, to keep the family property intact, the widow was forced to sati. The British questioned the validity of the custom of sati in the Hindu scriptures. While Raja Ram Mohan Roy advocated the abolition of sati, he was not initially happy with the British interfering in the religious matters. For the first time, Sati Prohibition Act of 1829 was passed, declaring sati illegal in British India. The modern-day sati of Roop Kanwar in 1987 forced the Parliament to pass the Commission of Sati Prevention Act 1987, which made the practice of sati a criminal act by law. The 1987 Act seeks to prevent sati practice or the voluntary or forced burning or burying alive of widows, and to prohibit glorification of this practice. It also prohibits creation of a financial trust, the construction of a temple, or any actions to commemorate or honor in the memory of a widow who committed sati. The Act prescribes punishments ranging from 1 year imprisonment to death sentence. One feature of the Act may be noted that the woman attempting to commit sati, though being a victim of the religious and social practice, is also liable for punishment as against the general principle of criminal law. Attempts to criminalize sati were made while enacting the Indian Penal Code, but were watered down by a few concessions inserted in section 300 of IPC. Under IPC, depending on circumstances, sati may constitute various offences like a suicide under section 305, or where sati is incomplete, it may be an attempt to murder under section 307, or an attempt to culpable homicide not amounting to murder under section 308, or an attempt to commit suicide. From the foregoing discussion, it is clear that apart from the specific law, there are enough and more laws on the statute books to punish those guilty of this crime. The Act of 1987 could have been in the form of amendment in the homicide sections of the IPC, declaring that henceforth sati or any kind of ritual killings shall be presumed to be as murder unless otherwise established by the evidence. Though the custom has been dying a slow death since the law came about, incidents of sati are reported even recently in 2002, 2006, 2008 and in 2009 as well. Widow remarriage. Following sati, widowhood is another kind of gendered oppression to which a woman alone was subjected to on the death of the spouse. Widows were not treated as human beings and were subjected to a lot of restrictions. They were not allowed to remarry. This cruelty on widows probably was one of the main reasons for the large number of women choosing to commit sati. But today, nobody will blink an eye when a woman remarries after a divorce or death of her husband. This shows that society progresses and accepts change when there is sufficient effort by the state, and law can be a powerful instrument in changing the society and its outlook. The earlier efforts for widows' remarriage were made by Pandit Ishwarchand Vidyasagar during the British regime and later by the Hindu Widows Remarriage Act 1856, enacted by the colonial rulers. The Act of 1856 enabled the Hindu widows to marry again after the death of her husband. This law gave a severe shock to the then conservative Hindu society. It secured legitimacy to children of such marriages. The Act, though legalized the remarriage of a Hindu widow, had the effect of divesting the estate inherited by her as a widow. By her second marriage, she forfeited the interest received by her in her husband's estate, and it passed to the next heirs of her husband as if she were dead. Remarriage of a minor widow shall be done only with the consent of her father or her other immediate male relations. However, the Act purports to impose certain disabilities in relation to the right of inheritance of a childless widow that can hardly be allowed to continue in the present structure of our society. It is therefore imperative that the Act should be reviewed and the law be made harmonious and in consonance with social justice. Later, in 1872, the Special Marriage Act 3 of 1872 was passed, which enabled one to marry out of her own caste. But it may be noted that the Act of 1856 has played its role and contributed in the upliftment of Hindu widows. However, the subject of the Act is fully covered by the 4 acts contained in the Hindu Code of 1956, enacted nearly 100 years later. These acts override all the rules of Hindu law, custom and usage having the force of law in respect of the matters dealt with in those acts. After these 4 acts have been enacted, the Act of 1856 has become obsolete and is no longer of practical utility and could therefore be considered for repeal. Immoral traffic in women. Another form of extreme violence faced by women is immoral traffic, or infamously called as prostitution. Though men and children are trafficked for various reasons, women and girls are more vulnerable to this slavery-like practice. What makes women and girls vulnerable are economic distress, desertion by their spouses, sexually exploitative customs, family traditions, false promises, false marriages, and kidnapping. Unfortunately, the society remains tolerant and silent to this crime against women. An estimated 5 lakh women and children are trafficked every year, with an annual increase of 10%, of which 20 to 30% are below 13 years of age. IPC predates any other laws in dealing with this issue. It contains sections dealing with kidnapping, abduction, slavery, buying and selling minors for prostitution. In 2013, sections 370 and 370A of IPC dealing with offences of trafficking supplemented the law. While Article 23 of the Constitution prohibits trafficking of human beings, Article 39 specifically obligates the state to create a protective mechanism for the same. The provisions of both these articles have been incorporated into the Suppression of Immoral Traffic in Women and Girls Act 1956, which underwent amendments and was renamed as the Immoral Traffic Prevention Act in 1986. This act, supplemented by the IPC, prohibits trafficking in women and lays down severe penalties. These laws were intended as a means of limiting and eventually abolishing prostitution in India by gradually criminalizing various aspects of forced sex work. The main points of the ITPA are as follows. A prostitute who seduces or solicits shall be prosecuted. Prostitution near any public place or notified area is also punishable. Persons who live on prostitutes' earnings are guilty of a crime. Landlords and brothel keepers can be prosecuted. Maintaining a brothel is illegal. The government is legally obligated to provide rescue and rehabilitation in a protective home for any sex worker requesting assistance. Thus, we see that the law does not prohibit or purport to penalize prostitution in general, but deals with commercial or open prostitution. Prostitutes can practice their trade privately but cannot legally solicit customers in public. As long as it is done individually and voluntarily, a woman can use her body in exchange for material benefit. In a way, organized prostitution is illegal. The problems relating to prostitution, child prostitutes and children of prostitutes have been the subject of a landmark judgment of the Supreme Court in Gaurav Jain versus Union of India. Accordingly, Committee on Prostitution, Child Prostitutes and Children of Prostitutes and Plan of Action to Combat Trafficking and Commercial Sexual Exploitation of Women and Children was constituted to address the issue. Detailed recommendations were made with a view to arrest the systematic problem, including issues relating to law enforcement and legal reforms. The role of NGOs in rehabilitating and educating the children of the fallen women was emphasized in Gaurav Jain case. It may be noted that no country in the world has been able to stop this institution successfully. Therefore, Instead of banning it totally, the law in every country has tried to regulate it so that it may be kept within its legitimate bounds without unduly encroaching upon the institution of marriage and the family. Indecent representation of women. While women are sought to be treated with great respect by the society, they are also depicted in an indecent manner for promotion of business or commerce. Women are represented in publications, particularly advertisements, etc., which have the effect of denigrating women and are derogatory to women. Though there may be no specific intention, these advertisements, publications, etc., have in effect of perpetuating the social biases, depraving and corrupting persons. Article 51 of the Constitution prescribes a duty to every citizen of India to renounce practices derogatory to the dignity of women. The law relating to obscenity is codified in sections 292, 293 and 294 of the IPC. These sections take care of preventing and punishing the offenders indulging in outraging the modesty of women and indecently representing women in certain forms under the guise of entertainment. But none of the provisions cover indecent representation of women in publications and advertisements, etc., which have an effect of corrupting and depraving persons. Accordingly, the Indecent Representation of Women Prohibition Act 1986 was enacted with the specific objective of prohibiting indecent representation of women through advertisements, books, writings, paintings, figures or in any other manner. It defines indecent representation of women to mean depiction of the figure, form, body or any part of a woman which is indecent or derogatory to or denigrating women or is likely to injure public morality. The meaning of obscenity was described by the court in Ranjit D. Udeshi versus State of Maharashtra that where obscenity and art are mixed, art must so preponderate as to throw the obscenity into a shadow. Section 4 prohibits the production, sale, hire, distribution, circulation, sending by post any books, pamphlets, slide, film, writing, drawing, painting, etc., which contain indecent representation of women in any form. An offender will face a 2-year jail term and fine up to Rs 2,000 on first conviction and enhanced punishments on subsequent convictions. Yet, advertisements showing women in an indecent way are aired every day and hardly any action is taken. It may be noted that the 1986 Act covers the print media. Considering the development of newer forms of communication, there arises a need to widen the scope of the law to cover the new forms of media. In October 2012, the law was sought to be amended. The bill seeks to broaden the scope of the law to cover the audio-visual media and content in electronic form, prescribing stringent penalties which would act as deterrent to violation of the law. Section 67 of the Information Technology Act 2000 is the most serious legislative measure against indecent representation of women. The issues the bill sought to deal with are already covered under the Information Technology Act 2000 and they have been stronger punishments than the ones given in the Act of 1986. A parliamentary panel has recommended the setting up of a central regulatory authority to monitor indecent representation of women. The National Commission for Women has suggested modifications in the Act and elaborates upon ways to strengthen it and make it workable so that the objectives can be achieved. Depiction of women when a product or advertisement does not warrant it should be avoided by all concerned like the advertisers, advertising agencies and the media. They should consider it as their corporate social responsibility to avoid indecency and vulgarity in the advertisements. It is also necessary to draw up guidelines for policymakers regarding advertising agencies and commercial production houses to encourage positive and realistic portrayal of women. It can be observed from the above discourse that a few enlightened visionaries worked with colonial rulers to bring about social change through legislative efforts. Some of the social evils, such as Sati, are no longer prevalent today. There are others like child marriage which still fester. This shows that law can be a powerful instrument in changing the society and its outlook. It may be noticed that while the progress has been rapid in certain areas such as family laws, there is much that needs to be done to address issues such as trafficking of women and girls. It is imperative that society shows the seriousness that issues such as child marriage and trafficking deserve, and regular legislative amendments are undertaken to address these issues. We may conclude with the contemplation that all social issues cannot be addressed through law alone. Social awareness and willingness to change as per times is a must. Appreciate your time for completing this session with us. Thank you.